What will 2011 bring? Well, a more buoyant economy is a possibility. Warmer weather, maybe, the sooner the better. Perhaps the start of Olympic frenzy. The retention of the Ashes, maybe. Well, that seems fairly definite given events in Adelaide overnight. But another definite is the inevitability of more problems for employers to deal with. And I'm going to run through some of those issues over the next few minutes. On legislation, the Bribery Act will come into effect in April 2011. This is important. The penalties are a 10-year maximum jail sentence and an unlimited fine. A new corporate offence is created of failing to prevent bribery and corruption by those acting on behalf of a company, and both the company and its directors can be liable. There's a defence if the company has adequate procedures in place, and the government is about to respond to consultation on that and publish guidance early in 2011. What seems quite likely is that for the defence to be made out, companies will have to have anti-bribery policies, contracts setting out the penalties for transgressing, training, and clear rules on gifts and entertainment. Once the guidance is published, you will need to get your policies drafted as soon as possible. The FSA remuneration code needs to be implemented as soon as reasonably practicable in the new year with a July 2011 long stop. Currently the code affects 26 firms. It's thought that approximately 2,500 firms are going to be covered by the revised code, and that includes banks, building societies, but also investment firms, and that catches a whole raft of organisations from asset managers, hedge funds, some corporate finance firms, venture capitalists, brokers, and financial advisors. Later this week there will be further European restrictions on affected firms, and the code will then be amended again to take account of these. Arguably, the effect of the gold plating of the code is to make organisations in the UK uncompetitive. Next, the Equality Act Codes of Practice. The Employment Code, 313 pages of it, which is a sign of the times and possibly not something you want in your Christmas stocking. These are statutory codes and also non-statutory guidance. They can be used as evidence in the Employment Tribunal, and you ignore them at your peril. The codes are already late. There's a draft on the EHRC website, so keep an eye on those. The default retirement age. This is probably going to be phased out between April and October next year. The outcome of the government's consultation is awaited. Again, this is late, but it seems that the outcome is pretty sure. There will be no notices of compulsory retirement capable of being issued after April, and no default retirement age retirements after October. For the future, beyond that, there are 2 points. Obviously, first of all, you need to consider taking action before April if you have people coming up to retirement. But then beyond that, you will have to justify a default retirement age, which is going to be difficult. And if you can't do that, then you're going to have to performance manage employees out of the business, whatever their age. The agency workers regulations, they come into force in October 2011. What they give is equal treatment for agency workers after 12 weeks employment on no less favourable terms than a direct employee as to pay and conditions. From day one, an agency worker has the right to be told of vacancies and has access to collective facilities and amenities such as canteens and the like. The way to prevent the workers' regulations applying is to have a 6-week break between contracts. Now, obviously, that is going to be commercially impracticable for many organisations. Again, on the definite, the additional paternity leave regs are going to come into effect in April 2011, and these extend paternity leave from 2 weeks to up to 6 months if the mother returns to work with unused maternity leave. Payment is at the SMP rate, which may make it unattractive, plus all terms and conditions of the contract continue, so very like maternity leave. But But do note the case of Alvarez and Cesa Start, which is before the European Court at the moment. This is a case, the details I won't bore you with, but the impact of a European Court decision which follows the Attorney General's view is that fathers should receive enhanced maternity pay if, under the employer's scheme, mothers would receive enhanced maternity pay. Now that could be a very major development, along with favourable treatment on redundancies, which might also apply to fathers taking benefit of that paternity leave. Time off for training comes into force in April 2011. It is already in place for organisations with more than 250 employees. All other companies will now be caught by it. There has been comment in the press that there is a smaller employer cut-off, but that is premature, and that would need to be clarified. It isn't in the legislation at the moment. Essentially, it gives employees the right to request time off for training, very similar to the flexible working regime. There has to be a meeting, a decision, an appeal, etc., etc. Consultation is ongoing, and the outcome of that consultation is expected soon. On the maybes front, in legislation, there is possibly going to be an extension of the right to request flexible working. It's all part of the grand plan to make life more difficult for employers, or is it to encourage us to have more babies? I'll leave you to make your own decision on that. Will it come into force in 2011? Well, possibly. I suspect it will, because it is part of the coalition agreement. There's another maybe on the legislation side. There is a problem, as you may have noted, and we may have told you in various pieces of correspondence, with the Equality Act and compromise agreements under that Act. Essentially, a legal advisor to the employee cannot sign off on a compromise agreement if the legislation is taken at face value. There are two views on this. It is unclear, and something needs to be done. Whether that will be revised legislation is up in the air at the moment. In terms of what to do at a practical level, if you are signing a compromise agreement with a significant cash payment or the risk of a discrimination claim, you need to consider alternative ways of dealing with this so that you get an effective compromise agreement. Sending the employee off to another independent lawyer is not the answer, because that individual would still be caught by the problematic drafting of the legislation. There's one long shot on the legislative side, and that's that the unfair dismissal qualifying period might be extended to 2 years. Just a bit of history. It started off as a qualifying period of 6 months, then it moved to 1 year, then to 2 years, and then back down to 1 year again. There was some press comment recently. A government minister is supposed to have made a remark about it, and perhaps we're all reading a little bit more into it than we should. It is very much a long shot, but do keep your eyes out for it. Moving on to cases, the European Court of Justice cases here. The first one you heard from Helen Besh earlier about Kraft and the Woodcock cases, which basically said that saving costs and resources could be a reason for justifying age discrimination. Will there be some further clarification from the ECJ? Possibly wishful thinking. European Court justice and European Court judgments tend to be phrased in Eurospeak, but hopefully there will be something authoritative there. The KHS and Schulte case, this is one of the long-running sagas about holiday pay and sick leave. Helen talked to you earlier about Khan and ways of avoiding the accrual of holiday. Well, the question here is, does the Working Time Directive allow statutory minimum leave for employees on long-term sick leave to expire at the end of the leave year? That would be a helpful decision for employers if it comes out that way. And the Alvarez case I mentioned a bit earlier, this is an important case to look out for in relation to enhanced paternity pay. It could significantly increase the obligations of employers. There are no firm dates for any of those cases to be decided by the European Court. In the UK, Supreme Court and Court of Appeal cases, the two R&G and Hamid cases, This is a hot topic. In the court below, in each case, the decision was that legal representation in disciplinary hearings could be justified and could be an obligation that an employer has to allow if the outcome of the hearing could have a substantial effect on an individual's ability to practice. So in areas such as teaching, the NHS, possibly the FSA. Hopefully these two cases, one is an appeal and one a cross appeal, will provide much needed clarification. There is no date yet for R&G. Hamid is going to be heard in February. Parkwood Leisure. Those of you who know about TUPE will know that the acquirers of businesses do take collective agreements that apply to the affected employees. The question is, do they take the collective agreement as is at the date of transfer, or the more dynamic interpretation, they take any subsequent changes to that collective agreement, even if they can't influence the changes. Parkwood, when it appears or is heard before the Court of Appeal, will provide some clarification on that. BP and Elstone, the appeal in that was heard yesterday, and therefore early in the new year there will be a decision. Oslam talked about this case in her presentation a bit earlier. Tullet, this is a Court of Appeal case which is an appeal from the High Court set piece battle of earlier this year. Helen talked a little earlier about this, giving some guidance on team moves. The case is floating next week, which means it'll start sometime next week, and the decision will be heard or be received sometime in the new year. Employment Appeal Tribunal cases, well, Olds, this is a case about pre-packs and whether a pre-pack administration allows a buyer of a business to escape the effects of TUPE. The decision has been reserved following the hearing. Just to give you a bit of background, on a pre-pack, is basically a stitch-up between the insolvency practitioner and usually the owners of the old business, under which they buy assets and leave the employees and liabilities behind. There's a technical point of interpretation on the TUPE regulations, but we await the outcome of that. Eversheds, this case is going to be heard in December before the EAT. Essentially what Eversheds did was give a woman on maternity leave a maximum score under one of the criteria that the firm was using for a redundancy selection, and it was essentially a maximum score on lockup, and the reason for this was that it compensated the employee for the lost opportunity. The man in the selection pool was given his actual score. He was selected, and he won in the Employment Tribunal a discrimination claim, and he was awarded £120,000 in compensation. We'll see what the EAT says. My view is that Eversheds just got it wrong. They chose the wrong criterion in this case. Karashi, that's a whistleblowing case that's going to be heard by the EAT in January. The point here is whether the requirement that a protective disclosure be made in good faith to qualify for a protective disclosure has to apply to all of the allegations or just some. In this particular case, some allegations were made in good faith, some were not, and the tribunal said that all must be. The employee is appealing. Buchanan, this is a TUPE transfer case, no date as yet for the appeal to be heard, and essentially what it was about was an equal pay claim where a transfer took place in 2002, and the employee was continuing to pay on the same basis as the contracts that it inherited as part of the TUPE transfer up to 2008, even though it had an opportunity to make changes to those contracts to remove the inequality. We will see which way that case goes. That brings me to the end of my session on the new problems, I think, rather than new opportunities that are going to be there in 2011 for employers.